Welcome everybody to Freedom's Law School's Freedom Rally. My name is Payman, your host and the president of Freedom Law School. And I'd like to invite you all to start this morning with us by picking up the copy of the American Freedom that was given to you when you entered the room. And please go along with me reading this together. This very important document that is part of a document that's over 200 years old, that many people seem to have forgotten about its word, intent, and its meaning. So together we'll read what it says. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed, that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it, and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. Prudence indeed will dictate that governments long established shall not be changed for light and transient causes. And accordingly, all experience has shown that mankind are more disposed to suffer, while evils are sufferable, than to right themselves by abolishing the forms to which they are accustomed. But when a long train of abuses and usurpations, pursuing invariably in the same object, evinces a design to reduce them under absolute despotism, it is their right, it is their duty to throw off such government and to provide new guards for their future security. In every stage of these oppressions, we have petitioned for redress in the most humble terms. Our repeated petitions have been answered only by repeated injury. A prince whose character is thus marked by every act which may define a tyrant is unfit to be the ruler of a free people. And for the support of this declaration, with a firm reliance on the protection of divine providence, we mutually pledge to each other our lives, our fortune, and our sacred honor. The above was taken from the unanimous Declaration of Independence of the 13 United States of America, adopted in Congress July 4th, 1776, which was signed by 56 courageous Americans. We started our meeting with this rather than a Pledge of Allegiance. And the reason for that is we tend to forget who has pledged allegiance to who. We tend to forget that the government are our public servants, that we the people are the masters of government, that it is not the people that need to pledge any allegiance to the government whatsoever, but it is our public servants who need to faithfully come through on their allegiance, on their pledge to you, we the people. And I submit to you, the problem is not in America that we do not have enough Americans who have allegiance to their country and their fellow Americans. But the problem we have today is not enough of our public servants take the pledge that they take to uphold and defend the U.S. Constitution from all enemies, foreign and domestic, and therefore protect your rights of we the people. We believe that pledge is being taken too lightly by them and very often violated. The purpose of this weekend rally is not only to enlighten and educate you and inform you as to what's going on, but also, in addition, to spur you into action that is results-oriented. In other words, if we reduce this meeting to another one of those meet, eat, and retreat meetings, where you hear about some speaker talking about some problems, and not much of a solution, then you're just going to go home more frustrated. Okay? We don't want that. I don't believe you do either. You want some results in your life to live free now. That's why on the top of the page it says live free now. And so the speakers we have brought to you this weekend will do just that. Show you how you can start living free now, okay, as well as educating you. Our first speaker is a personal friend of mine. He has a bachelor's of science in electrical engineering, master's of business administration in finance and marketing. He has a doctorate of law in School of Hard Knocks, as you'll find out momentarily why. He has held a number of business positions and has been a real estate broker for over 20 years. He's also a graduate of Freedom Law School, and he successfully sued the California Franchise Tax Board and won a jury verdict against them for over $337,000. And despite the doubt of the naysayers that would say, well, I'll believe it when I see the check, he got the check last July 20th. He's a personal friend of mine, a great freedom hero, someone who I'm proud to have been able to convince to come join Freedom Law School on our dream team, a great freedom lover and freedom fighter, a man I truly admire and respect, Mr. Paul Ballmer.
Thank you very much, Paymon. If we have a timekeeper, Paymon, so they can give me about 10 minutes, I can. Well, I want to make sure that I cover what's happening right now, and so, as Paymon mentioned, on March 29th, I received a 12-0 verdict against the Franchise Tax Board for damages, and they immediately filed a notice of appeal. But on July 23rd, they withdrew that appeal and sent me the check for $337,000. Dave Wellington. Could you turn on the check? If you can't see it on the overhead, it's also in the page 27 of your program. So, but during this time we had actually spanned a period of 8 years. There were 4 years in which I worked administratively, writing letters, and then 4 years in the courts. There were 2 trials, an appeal, primarily regarding the government's immunity, 10 to 15 appearances for motions, mediations, status conferences, and at one point they offered me $1,000 to settle. Then later during one of the mediations they upped that to $20,000. So, you know, they were being obviously very generous. But I think it's very important to understand that mine was not a tax case. And I want to make that distinction very clear, but my case solved a tax problem. And the reason for that is that in the Information Practices Act, which is in the Civil Code 1798 and the sections after that, what happens in this law is basically a prerequisite to the tax code. And the Information Practices Act directs the manner in which the government agencies can collect, maintain, and use information. It's equivalent to the Federal Privacy Act, but it's a lot more powerful, I believe, because there's a prohibition in the IRC to not use the Privacy Act, the Federal Privacy Act, in a tax matter. But that doesn't exist in the federal case. So what happens is that if they take the information out of their file that they're not supposed to have there, then the assessment falls, the liens fall, etc. I also want to make it very clear that my case was not about money. My case was about power, the Franchise Tax Board's power, because they have enormous power and they exert that power without fail. It's also about surrender, forcing you, your neighbor, myself to surrender. That's what they want more than anything else, is they want you to surrender. And the way they do that is they intimidate you and they drag it out. In my case, 8 years. They send you down false roads. They do everything. They file various motions, and they do everything in their power to thwart you in any kind of redress of grievance. We don't have redress of grievance anymore. So the Information Practices Act, what it does is it allows you to have access to your files, to know the source of the information in the files, to request a correction of those files. The act was enacted in 1977. 77, that's some 23 years, and it has eluded the Patriot movement during all of that time. I could not find any appellate cases with regards to the IPA and the Franchise Tax Board. But it has numerous advantages over the tax code. First of all, it's very clearly written. It's only about 15 or 20 statutes which are pertinent. There's a relatively simple administrative process to make the corrections. It applies to all agencies in California, and it governs the privacy notice. Dave, could you put the privacy notice on? Now, what happens is that they slip this in the back of the instruction manual, or they used to put it in when if they sent you a request for return, they would slip this in. And because of time and a little difficulty in seeing what's going on here up front, I'm just going to leave this privacy notice up here and direct you to, and you can leave the privacy notice up, Dave, but the IPA covers the privacy notice, and it's under Section 1798.17. And let me just run down some of the requirements, and you tell me if you see these requirements being met in the privacy notice. First, the name of the agency and division. Okay, now they come back with something, the branch or something totally different. The title and business address of the telephone number of the agency official. They give you an 800 number, you get some clerk who's never heard of the IPA. Okay, C, the authority, whether granted by statute, regulation, or executive order. Do you see where they tell you what the authority is for them to ask you for a return or to do anything else? So there's 3 or 4 other requirements in 17.98. I would just direct you to review that and check out the privacy notice. That's just one area. Now, another very critical statute is 1798.17, and that's on 3, Dave. Each agency shall maintain in its records only personal That's the key. Only personal information which is relevant and necessary. Well, in my case, what they did was they took the average income for a real estate broker from the city of Los Angeles, and they virtually planted that in my file. And they do this for anybody that has a license. There are some 50 or 60 licenses in California. And if you don't file a return, and I haven't filed since about 1979, either a federal or state return, but if you don't file a return, then they now have a program called the Personal Income Non-Filer Enforcement Program. It's a highly sophisticated computerized program, and they go after people that have licenses. If you have a business, they will estimate your gross income, the cost of sales, etc. If you have a mortgage payment, they will multiply that by 4 and come up with an income. And also property sales, they will take 50% of the property sale and claim that that is your basis. So basically, they're doing all of these things in violation of 17.9814, which says that they can only have personal information in your file. And there are numerous other violations. I would direct you to 1798.32, which says that when they send you a notice that they have to tell you how to get access to the files, the procedures, on and on and on. There are so many violations when you really begin to study what's happening. In fact, I have written and gotten asked them, they're supposed to appoint somebody to implement the IPA in the agency. And they have virtually done nothing. So these people, they don't even know about the IPA, and the Franchise Tax Board acts, you look in any of their literature, and except for the Privacy Act, there's really no mention of the Information Practices Act whatsoever. So I want to move on and talk about the trial a little bit. The Franchise Tax Board had no rebuttal. They had no witnesses, no documents, no evidence that they had implemented the IPA. Think of that. We expected that it was going to be about a 5-day trial. It turned out to be about 2 days because they've, other than cross-examining me on the stand for roughly 20 minutes and asking me why I didn't file a return, there was virtually no rebuttal whatsoever. I had an expert witness. I had had some counseling from a member of my church, and he proved out, and they admitted him as an expert witness, and that proved out to be very substantial testimony. Because one of the big advantages in the IPA is that it provides for damages, both compensatory damages. In other words, if the Franchise Tax Board has taken money from your bank account or some other method, sold your house or whatever, those are compensatory damages, and you can get that back. But you're also entitled to emotional distress, and that's what my award was for emotional distress. In other words, of the $337,000, $250,000 of that was for emotional distress. $78,000 was for attorney's fees, $5,000 was for interest, and $5,000 was for costs. So in the tax code, there's no provision for damages. There's no provision. Another big advantage is that there, in the IPA, is that there's provision for attorney's fees. It's a totally different situation in the Revenue and Taxation Code. I want to talk about the good decisions that, fortunately, I made during this 8-year period, because these are all very critical. And the first decision was to work with an attorney. In an offensive tax case, which is, I will say, it's certainly tax-related, it's not a tax case, but as I've been involved as a paralegal and involved in a number of IRS cases and so on, and spent a lot of time in the library, there are very few pro ses that can match the government's procedural tactics. Demurs, motions, time factors. Oftentimes, the pro se will never even get the issues past the initial summary judgment or demur, will never even get that in front of the court. And they are so skilled at presenting these procedural motions and all of these hurdles and tactics that the pro se just doesn't have much of a chance. So the other areas where the attorney in my case came in very helpful, because he's a trial attorney, and he does this day after day, week after week, but in the voir dire, in the selecting of the jurors, in the jury instructions, in evidence, getting evidence into court. All of these things are extremely critical. And in my case, the 15th juror was someone who had some experience with the SEC. In other words, he'd had a run-in with the government. And so we did what we needed to do to get that juror on the panel, and it turned out to be a very, very critical decision because he became the foreman, and I know that he was instrumental in upping the award at least from about $200,000 to $250,000, because he said, well, it's been 8 years and I'm entitled to some interest on that money. Another very important factor is to keep the case out of the Revenue and Taxation Code. There's this magnet, if you will, that if you're trying to resolve a tax problem, that well, we got to go into the tax code, and there's no statute requiring you to file, and there's this and there's that and whatever. If you file a tax day, you want to do everything possible to stay out of that. Another very important decision for me was to go with a jury trial the second time around. The first trial, we were in court probably not more than a half an hour. They did it to us procedurally, and what they did was they moved a motion for non-suit, and before we even got through the opening statements, Derek finished his opening statement, the Attorney General started his, the judge initiated a motion for non-suit, the Attorney General jumps up, yes, motion for non-suit, dismissed, we're out of there, okay? So the second time around, we debated and debated, well, if we go for the jury, they're obviously going to feel that, maybe they should vote against me because they all file returns, and we need to get over that hurdle. But we were successful in doing that. Another very critical point was I had made a transcript of one of the appeal hearings, and the jury read that, and they realized how arrogant the Franchise Tax Board is. Okay, well, what's happening now? Well, guess what? The Franchise Tax Board has not learned their lesson, and they're coming after me again for 1997 and 98 for my mortgage, multiplied it by 4. Where did they get the 4? Well, you see, they're supposed to provide the source under the IPA, but they never give you the source, and not only that, but the 4 is what? The 4 is not personal to me. I mean, a mortgage payment could be 2 times your income, could be 5 times, 2.5, whatever. They literally pulled this right out of the air. Another thing we're going to do is, and I'm in the process, I'm probably a few weeks away from filing that complaint, and there are many other issues which I've discovered, which hopefully we'll be able to get into the court. But also I have 2 other co-plaintiffs which are going to join me. One of the things I had tried to do the last time around, or the first case, was to bring in other witnesses who had similar FTB problems, and the state objected, irrelevant, and none of the witnesses, of which Payman was one, were able to testify. So this time we're just going to make them co-plaintiffs. One has been writing letters for about 2 or 3 years, and the other one's been writing letters for about 10 or 12 years. So, but in an IPA case, there's a fair amount of it. It's not, in some respects, it's not a difficult case, but it's a very tedious case because there's a lot of detail involved, and you have to establish the violations before you file the complaint, before you put the case together. And this time, we'll have the money, thanks to the FTB, we'll have the money to do some depots, to go up and get the employees from the Franchise Tax Board and ask them a lot of these questions which we didn't address the first time around. We're going to subpoena 4, 5, 6 of the employees. I'll just make I have to tell this story about, again, where an attorney is really helpful, and that is We go to court the first day, and Derek had filed what's called a subpoena in lieu, where we wanted 4 or 5 of the employees from the Franchise Tax Board. In other words, the Attorney General was supposed to have those people in court. Obviously, they objected, and the judge asked Derek, do you want to have these people do you want to have these people here to testify? Well, sure. Okay, well, you get me the paperwork tonight, and I will issue a body attachment. How many of you have heard of a body attachment? I didn't have the slightest idea what it was, but I figured out what it was. And basically, so Derek goes to the library, drafts the paper, has the secretary come in early the next morning, shows up with the paperwork, and the judge denied the motion. But if we had gotten the body attachment approved, they would, as my understanding, they would have faxed that order to Sacramento, gone into the Franchise Tax Board, handcuffed the employees, put them on a plane, and brought them down to Los Angeles. I could not have been happier that first evening after the trial. But this time we're going to serve them, you know. And another thing that I plan to do is to bring in the BOE, the Board of Equalization, as a defendant. Why the Board of Equalization? Well, when I went up for appeal, the Board of Equalization asked me for a return, okay? And they dismissed my case, my appeal, because I didn't file a return. But guess what? They never gave me a privacy notice. When an agency asks you for information, they're supposed to give you a privacy notice. Where is that privacy notice? Are they going to rely on the Franchise Tax Board's privacy notice? They didn't give me an adequate privacy notice anyway. So we're going to do what we can to incorporate the BOE as a defendant. Also, we're going to hopefully litigate the authority issue, and this is something which I think has eluded the Patriot community also for quite a while. And that is, in both the federal code and in the state code, what happens in the state code, the authority is, okay, it comes from the people to the legislature, to the Franchise Tax Board, to the executive director, who is Gerald Goldberg. Well, guess what? Based upon the research that I've done so far, Gerald Goldberg has never redelegated that authority to any agent, officer, employee, or person in the Franchise Tax Board. Think about that. Now, you have a similar situation in the IRS, in the federal situation, where you have these collection agents running around, and they don't have the delegated authority. So, but when you read cases and when you go into court, what happens is that they will say, well, the FTB has the authority, it's right here in the statute. But I maintain that that's not the question, because the individual, how can a government employee determine what my tax liability is? How can a government employee look for my file, look for whether I filed a return or not, when it's a voluntary on my part? I maintain that he can't do that he has no authority to do that. So that's one of the issues that we expect to litigate. Another tactic that I've just implemented is to, because in the first case, what happened was they put me on the stand and they asked me why I didn't file a return, and I said that I couldn't find a statute that made me liable, and so on and so on, and it didn't go much past that. But this time, what I've done is I've sent them a blank return and a power of attorney so that they can file a return for me. Now, they have the power to file a return. Section 19087 in the Revenue and Taxation Code gives them the authority to estimate the net income. That's the one that they typically rely on, okay? Estimate your the net income, but they never estimate your net income. But also, under 19504, the Franchise Tax Board, for purposes of administering its duties, et cetera, including the making of a return where none has been made, So they have that authority. In other words, Gerald Goldberg has that authority, the Franchise Tax Board has that authority, but they never make the return, and they never sign it under penalty of perjury. So those are a couple issues that I would suggest if you are looking at the NPA as a way to sue an agency, that you would want to take a look at that. How are we doing on time? We have a timekeeper? No timekeeper. I guess I can. Talk forever. Yeah, I can talk forever. Believe me, I can too. About 25 minutes. I've been up here for 25 minutes? Wow, time flies when you're having fun, doesn't it? Okay. Well, I'll be around this weekend if any of you have any questions. I'm looking for people that are interested in suing the Franchise Tax Board and working with them either on a coaching basis, or they can purchase the course. Last year when I appeared at the Freedom Rally, it was about a week after the trial decision, and they had filed an appeal, and so I put together this course in conjunction with Paymon. I spent about 9 hours in teaching the course, and we put together this manual which has about 300 or 400 pages in it. It has the complaint, the answer, the demurrer, the PIT enforcement manuals, all of the exhibits that we submitted. I had about 70 exhibits prepared to submit to the court. We submitted about 25 of those, I believe. And that's another place where Derek was very helpful, because one of the drawbacks in the patriot community sometimes when a pro se goes to court is that they have all these issues, you know, and maybe and it's just overwhelming, and they don't do justice to any of the issues. So one of the things that was very helpful was Derek kept hammering on me, we got to, you know, distill this down, and so we ended up going to the jury with only 2 questions. I mean, that scared the hell out of me, but the questions were, did the Franchise Tax Board violate the IPA? Now, technically they only have to, you know, be late on a letter for 10 days, and they violated, or a response, and they violated the IPA, but no court is going to give you any kind of a standing or maintain your case in that situation. But I had about 60 or 70 violations. I mean, I had so many violations that we couldn't even enumerate them all, okay? So we went with the major violations. We broke it down. We submitted only about 25 of the exhibits. So we only had 2 questions. Did the Franchise Tax Board violate the IPA? And if they did, if the answer to that is yes, then what is the amount of damages that Ballmer is entitled to? And I might comment on the damages because in an emotional distress case, there are no rules for how much an emotional distress case is worth. It's all the way from 0 to tens of millions of dollars. It's totally up to the jury. They could have awarded me $1, 0. They could have awarded me $2 million, $20 million. It's all up to the jury. Well, I asked Derek, and Paymon asked Derek if he would come and speak to you briefly. So I'm going to ask him to come up and tell a little bit about my case and some of the other things that he was doing. But briefly, Derek was born in 1953 in Glendale. He graduated with a bachelor's degree in business in 1974. He obtained his law degree in 1978, and he's a member of the California Bar since 1979, the year that I stopped filing, for whatever that's worth. His practice emphasizes civil and criminal litigation. He's recently handling several appeals, including tax matters and, of course, Ballmer versus the Franchise Tax Board, number 1 and number 2, and who knows how many more. He successfully defended a charge of will or failure to file a felony case in Malibu, and he's been handling the search and seizure motions and issues for Nick Jessen, who I believe is going to be speaking here tomorrow. So, my attorney and friend, Derek Taboni.
Thank you. Lest I ever try and get a big head about some of the things I've accomplished or not accomplished, I have my family to keep me on the straight and narrow. It's my family who comes to me and says, well, you know, Derek, what's the difference between a catfish and a lawyer? I said, well, I don't know. And they said, well, one is a bottom-feeding scum-sucker, and the other is just a fish. And I've got this little magnet on my refrigerator, which I didn't put there. I think one of my so-called friends did, that says a lawyer's principal job is to protect his clients from other members of his profession. That one actually is true. I don't have any complaint with that. I don't like the fact that it's true, but it is. I thought I'd give you a lawyer's perspective on these and similar types of cases. And I'm going to step back and say that, you know, I graduated from law school in 78 and passed the bar in 79. And I went to a traditional law school. I went to a Jesuit law school at Santa Clara. And it gives you a very rigorous intellectual training, but doesn't really, the Jesuits are very formal and very structured people. And so I'm not from a background that predisposes me to challenge everything physically, but maybe intellectually. So you get into these things, you got to look at who you're dealing with. And before you take one of these cases on or decide to do it yourself or hire a lawyer, you got to decide what you want and what your goal is and how you're going to accomplish that goal. Let's start out with the judges, because every case has got to have a judge. In the federal system, and if you're dealing with the IRS, you have to be in the federal system. You can't deal with it anyplace else. Judges are appointed for life. The thought in that, and back in 1800s when they decided to do this, was that the judges would be free of political influence. And to a certain extent, that was correct. When you're appointed for life, you don't have to kowtow to anybody for any reason. And some judges have issued relatively courageous awards against the federal government for either huge amounts of money or environmental damage, or there have been district judges that have stopped cold acts of Congress that passed with 2/3 majorities. On the other hand, appointment for life you tend to get arrogant, self-centered people who think they're a little above everybody else. And you've got to deal with that. On the state side, judges are appointed, well, actually they can be elected or appointed. They have a 6-year term and they have to run for re-election. Almost all judges are appointed by the governor. You can run for an open seat. Anybody who's got a law degree can run for an open seat. But of the 350 judges in Los Angeles, I think there's probably 5 that have run for office and the rest were appointed. But they have to rerun every 6 years. And what that means is they have to both raise some money and they have to not have any negative press or influence. What that winds up meaning is that they have to kowtow at least a little bit to the prosecution. The one thing that will kill a judge faster than anything else is to be called soft on crime. The second thing that happens with respect to state judges, which is where you'll litigate against the Franchise Tax Board, is that most of the, even though we've got a state that is more Democratic than Republican, we've had more Republican governors than Democratic governors. Republicans have uniformly appointed, by and large, people from the prosecution side, basically state prosecutors and county prosecutors, DAs, to the bench. Those people, some of them have been excellent jurists. I would never trade some of them away. A lot of them, however, tend to be rather focused. They don't like civil cases. They've never practiced civil law. They don't have any understanding about discovery rules, nor do they really care. And they're pro-government. They're very much in the system. So when you go into this, you've got to realize who you've got as a judge. You're most likely going to get an ex-prosecutor who has to run for office in the next 4 years. And the reason they want to stay in office is because the real money isn't made as a judge on the bench. You make the $140,000 a year, and I'm not saying that's bad. But when you retire after 20 years, you go into private judging, you collect a pension of $90,000 or $100,000 a year, and you make $400 to $600 an hour doing private judging with no overhead. Not a bad life. So they don't want to lose that job. They want to stay in office. They certainly don't want to be thrown out. The second thing you got to look at is who your jury pool is going to be. It's roughly the same in both federal and state systems. Recently, there have been some changes that have actually expanded the pool and made it maybe a little more favorable for these types of lawsuits. traditionally, the type of people that wound up on juries were people that didn't have a good enough excuse to get out. Well, some people actually like to be on juries, and I don't have any problem with that. And there's good jurors also, a lot of good jurors. But the people that had an excuse to get out are people that basically had a financial or family problem where they said, I really can't do this, and they would be uniformly dismissed or excused. You would get jurors that had either government jobs because they couldn't get out and they were paid whether they were on jury duty or not, people with large corporations that had to do the same thing, or people had government contracts where the government insisted that their employees be allowed to participate in jury duty, or retired people. Now, retired people are great, but they basically all draw Social Security, and they all want to see that check come in every month, and they view anything in the integrity of the tax structure as maybe affecting their right to collect their 8% increase in the next 2 years. And anybody else is going to not only have some tie to the government almost, but they're also going to have, and that starts with the judge and works all the way down, they're going to have withholding from their paychecks. You're not going to go in with a lot of sympathy. Now the system's been expanded. Basically, if you make more than about $30,000 a year, you can't be excused no matter what. Now, I have been excused from the past because I've not only worked for myself, but I've got 3 people working for me. If I don't sit in the office for a week, not only don't I eat, they don't eat. That used to be a good enough excuse. It no longer is. It used to be an excuse if your employer did not pay jury duty, and it was a financial hardship. That's no longer, like I said, you make $30,000 a year or more, and most people do now, there's absolutely no excuse. They will sit back and the judge will tell you, take a week of vacation. Well, I don't want to lose my vacation. Sorry, this is an obligation of citizenship. You must do it. Take a week of something else. Take a personal leave. Doesn't make any difference if you get paid or not. You can't take the time off. You're self-employed or not. I've got 7 minutes left. Paul, you took too much of my time. So that's who you're going to have sitting as your jurors. Now, because you can't get out of it, you get a broader range of people. You get people that don't want to be there, first of all, and have to be there, but you also get self-employed people, people in small businesses, and they're not quite as pro-government. Where that really comes down, and I'll talk about this briefly, and one of the reasons the movement seems to have problems finding attorneys is you not only have a problem with who you're going to have to try the case to, judge and jury, but you've got a problem with some of the arguments that you have to make. There's both in Rule 11 and in California, there's a companion or similar statute that hasn't quite developed as well or as fully, a 128.7 of the CCP, Code of Civil Procedure, 5 minutes. It basically says whenever a lawyer files a paper or a pro per files a paper, he's got to have a good faith belief in that, what he's doing. And that means both objectively and subjectively. He's got to believe in what he's doing subjectively, and he's got to have some objective reason for that. There's got to be some facts. If they're facts stated, he's got to have done a little bit of investigation, or at least believe the facts are real. And if he's got a legal position, it's either got to be warranted by existing law or a good faith argument for either extending existing law or changing existing law. What that means is you make a completely BS argument, and you can get sanctioned. I have seen sanctions in 6 figures in the federal system against lawyers for filing papers that they were told didn't have any objective merit. And one of the last cases I handled was for somebody who was fighting his employer, saying the employer had an earnings withholding order. He sued his employer to stop it. I got involved when this thing was in summary judgment, and after they spent $30,000 in attorney's fees on the other side, lost the summary judgment, but managed to keep him from losing for $30,000. They wanted to sanction him $30,000 for objectively frivolous lawsuit. He was pro per. I managed to stop that by finding enough arguments, which is probably the best thing I did for him. But you've got to be aware of that when you go into these things. As a pro per, you can get tagged even on a on a case where there are no attorney's fees awardable if your position is objectively meritless, and not to you as a pro per, but to an attorney. If an attorney would look at this position and say, this position has no merit, you're going to lose. And you can wind up losing the entire attorney's fees for the other side if they know how to do their procedure right. In this case, they didn't, and I had some other arguments. The last couple minutes, I'm going to talk about what happened in Paul's case, just very briefly. One of the things that happened, we were putting these codes up on the board and these letters that weren't responded to and the stupid responses the Franchise Tax Board made. The judge pulls me aside with the people's attorney, the Attorney General's office, and says, "You got to get rid of this and you got to get to the point of these codes. Just get to the point of this lawsuit." I'm sitting there saying, "Judge, this is the point." And the best thing about it was that's what we were able to sell to this jury. There's no pizzazz in these lawsuits. There's no flash. There's nothing to grab hold of and say, "Man, I had an interesting day in court today listening to these people talk about my card on the floor, about the exciting Information Practices Act." But a jury will listen to it. And the way I had to approach it, and I told them up front, it says, "I'm going to be asking you to award my client money. Your taxpayers, that money is coming out of your pocket. Make no mistake who's paying the freight. If you tell the state to write this man a check, it's your money." And I told them that about 13 times because I wanted them to make absolutely sure that I wasn't trying to put something past them. There wasn't phantom money I was asking them to award. It was their money that they paid to the state to do their business properly that they didn't. They bought that. And what our fear was, Paul and I, was that the jury was going to come back and say $6.50 because it was their money. Fortunately, they did not. Fortunately, they looked at this case, looked at his very real distress, looked at 25 violations that they could see and smell and taste, and looked at pieces of paper, looked at the transcript from a hearing that there was just baloney, just garbage, and said, "Well, you know, my argument was the state expects you to follow the rules. Okay, I'll live with that. They got to do the same thing." And that's all this was about. They have to follow the same rules that we do, and the rules that are provided for them, and if they don't, there is a remedy. If you're being taken advantage of by somebody who's not following the rules, there's a remedy. But you got to do it right. You got to know what you want to accomplish, and you got to focus it. Because if you're going with a blunderbuss approach, you lose. You go in as narrow, laser-like as you can, and you've got a chance. And if this process is going to spread at all, it's going to spread very slowly, and it's going to spread on a very focused basis from one building block to the next, an inch at a time. Thank you.
Thank you, Derek, and thank you, Paul. It's time for a break, folks. Let's take one. Now, here's what we're doing with the breaks. We're giving you, after every speaker breaks today, tomorrow after either one or two speakers. As you notice, we don't have a whole lot of walking way out here. So you need to kind of work along with each other, passing each other, and watch out for the cameras. No, knock them out, please. But please, when you announce the breaks, you need to be back in your seats on time so we can start the program, folks, without a lot of noise. And with the vendors and speakers, you got 2 days to get to them. So please, at the time on your own, be back in a seat. And let's start a program on time at the, well, let's give it a 5-minute extra. Instead of 10, what time is it right now? What time do you guys have? 10 o'clock? Okay, let's be back at 10:15.